Had a long day, Mr. Justice, but from the time I've been here, it seems like you've had a pretty good day. And let me at least close out my questioning by asking for a couple clarifications and also to go into a little bit the privacy questions, Ninth Amendment. I understand in response to a question from Senator Metzenbaum, you indicated that you would not belong to a club that discriminated based on race, but you would not feel bound not to belong to a club that discriminated based on sex. Is that correct?
No, that isn't quite what I said, Senator. I said that I regarded the two as quite different, and that I would think that a club that discriminates on the basis of race or on the basis of religion would be invidious discrimination. I think the jury's out on whether it's invidious discrimination to have a men's club. That's what I said. I didn't say that
Sorry, I didn't hear the last part. The jury is out?
I think that there's room for disagreement on whether a social club that's a men's club or a woman's club is invidious to the other sex.
Could it be invidious if, in fact, the effect of keeping women out was to have a detrimental impact upon their ability to do business, or if they were business women, or participate in sport if they're sportswomen? Or
I can see that, Senator. Yes.
Would you? Where do you put the classification? I mean, in what context would you place those clubs which would discriminate based upon nationality?
Well, there's sort of a affirmative and negative discrimination, I suppose. There certainly. I've been a member of Italian American clubs that members share a common heritage. The exclusion of others is not an invidious exclusion at all. And
if in fact,
likewise, religious clubs. I mean, they're Knights of Columbus and whatnot. They exclude people of other religions, not invidiously, but just because they get together to celebrate what they have in common. I think that's the key to it, whether the exclusion is an invidious one or not.
If in fact there were a club or an organization that included not one group of people who shared anything in common other than the fact they didn't like the Irish or the Italians.
Yeah, I think that'd be invidious.
You've been questioned on this already, but in your, get to make sure I have the right title of the article, referred to as the Panhandle magazine article.
Yes, sir.
I understand that one of my colleagues quoted you, the provision that said, "I do not care how analytically consistent with analogous precedent such a holding might be, nor how socially desirable the judge's view, nor how socially desirable in the judge's view, if it contradicts a long and continued understanding of the society, as many of the Supreme Court recent constitutional decisions referred to earlier in fact do, it is quite simply wrong. There will be no relief from the most far-reaching intrusions of the modern judiciary until the Supreme Court returns to this essentially common law approach to constitutional interpretation." Now, as I understand it, if in fact it were a long-established societal view, it would. Why don't you explain it to me?
Let me try, Senator. I am deeply mistrustful of my ability, without any guidance other than my own intuition, to say what are the deepest and most profound beliefs of our society. And that's what it means to say that something is constitutionally required. it is in accordance with the deepest and most profound beliefs of our society. I find it difficult to come to the conclusion that something qualifies for that description when neither at the time the constitutional provision in question was enacted was it in fact the practice of the society as demonstrated by the laws that the society enacted, nor at the present time is it that way. Now, I can understand, and you get into the debate between the evolutionists and the original meaning types when you say, well, what if everybody now thinks it's awful and there are no laws on the books of this sort today, but there were in 1789, so it must be constitutional. It seems to me that's a good debate. But I find it very difficult to say that it's contrary to our most fundamental beliefs when both in 1789 and today, all of the states have, permit the practice in question, whatever it may be. Once you don't give me that to hang on to, Senator, I worry that I'm left with nothing to tell me what are our most profound beliefs except my own little voice inside, and I do not want to govern the society on the basis of that.
Well, let's talk about the Ninth Amendment in that context. The decisions, and I don't expect you to comment on how you would rule, but the decisions that have arisen that have been somewhat controversial, where the right of privacy is asserted as being a right that is protected or recognized under the Ninth Amendment. I guess maybe that's the place to start, the Ninth Amendment. You believe that the Ninth Amendment, in fact, implicit in the Ninth Amendment is a recognition of a right called the right of privacy, not to what extent that applies, but that there is such a thing as the right to privacy.
I think that's in effect asking me to rule on cases. I can say the Supreme Court has held that there is such a thing as a right of privacy. They haven't tied it to the Ninth Amendment. As far as I know, there's no Supreme Court holding that rests any right exclusively on the Ninth Amendment. They mentioned the Ninth in a litany of amendments from which various penumbras emanate, and
do you believe
the
that
Ninth
there
was among
is
them.
such a thing as a constitutional right to privacy? Not delineating whether, for example, the right to terminate a pregnancy relates to the right to privacy, or the right to engage in homosexual activities in your home is the right to privacy, or the right to use contraceptives in your home is right. But is, in a philosophic sense, is there such a thing as a constitutional protected right to privacy?
I don't think I can answer that, Senator, without violating the line I've tried to hold.
Judge, I don't know how you...
I can tell you that that's what certainly a number of Supreme Court opinions now say.
Well,
But there's somebody may come in and say, just as somebody might come in and say Marbury versus Madison was wrong, that it doesn't exist.
Sure, they may come in and say it, but
that it shouldn't exist. I do not want to be put in the position of having I'm sorry, I believe in the right of privacy because I told the committee in connection with its considering my nomination that I believe in it.
Well, the fact you believe in a right to privacy doesn't mean that that a case before you, in fact, rise to the level of being guaranteed that right. I mean, I think you're being a little bit disingenuous with me here. If, in fact, you conclude that there's an existing right to privacy, that in no way predisposes you to have to rule one way or another about whether or not a right is claimed as being qualified under such a right.
No, Senator, I beg to differ. There has been scholarly criticism of the whole notion of right to privacy.
Well, I agree.
And it's not at all inconceivable that criticism will be reflected in a brief before the Supreme Court. And
well, that very well may be, but it doesn't. In other words, if the right to privacy exists, if you believe the right to privacy exists, and I believe you have stated in What was that in the CNNB case? Okay, sir, was that in the article? Excuse me one moment. Pardon me? I believe, and I can't pin down where you said it. It was in an article?
I don't think you'll
In
find
the
it, Senator.
Panhandle article, did you say that that the right to privacy is one of the deepest and most profoundly held beliefs in our society?
I don't recall having said that, Senator.
Oh, I see. I'm sorry, I misspoke. What was being referred to was your answer to me earlier, saying that in order to meet your test, it has to be one of the deepest and most profoundly held views in society. And you always, do you have any doubt the right to privacy is one of those deeply and profoundly held view of American society? Forget the Constitution. Let's just talk politics, you and me.
It's very hard to answer. You began this line of questioning by answering me, never mind what the right of privacy consists of. I can't answer that question without knowing what you mean by the right of privacy.
Sure, you can acknowledge whether or not you believe there is, in fact, let's start over again. Clean the slate. Do you believe that Americans as a whole believe that there is a right to privacy that they have, inherent, that they think they have a right to privacy? Do you think that's a deeply and profoundly held belief by American society? Whether it's found in the Constitution or found in natural law or found in their Bible or found in the Talmud, as a society. I mean, do you have any doubt that Americans believe?
I'll give you that, Senator. I think
Good man, I tell you, we're getting there. All right. Now, having said that, do you believe that is there any doubt in your mind that the Ninth Amendment, in conjunction with other amendments as it relates to particular assertions of particular rights of privacy, if I can find the Ninth Amendment here so I don't misquote it. Do you have the Ninth Amendment sitting there? Dig it out for me, will you? Roman numerals confuse me, Judge.
Let's see if yours is the same as mine. I have one here, too.
All right. I almost read the 11th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Is there any doubt in your mind that the people, at the time and now, believe they have retained the right to privacy, whatever that means?
No, I think there's no doubt in my mind of that.
Okay. Secondly, if in fact well, I don't have to go any further, actually. Because in fact, it seems to me if there, in some form or another, there is a constitutional protected right of privacy. What that means remains to be seen, whether it means the right to engage in homosexual activity in one's bedroom, or anything else remains. I'm not going to ask you to comment on that, but let me. Again, I guess my time. I know my time is up, but let me pursue this one step further, if I may. When I look at your musings on the, and I don't mean that in a derogatory way, because I love to read what you've written. I love the way you go about it. I mean, I wish I had you in class. I'm probably too old to have had you in class, but you're the kind of guy that I would have liked to have been in class. I could have gotten by with you because we could talk about philosophy. As long as you didn't ask me what the case stood for, I'd be all right. But when I tie your musings on original meaning and original intent, and where I must admit I put you more in the school of the original intent fellas than I do in the living Constitution area, I begin to be concerned about, and then when I take your second stated principle in the Panhandle article, which is basically that if it is a long-held societal view that has been, in effect, recognized through constitutional interpretation, case law, Supreme Court cases, then you would be very reluctant to overturn it. If I read that correctly, or am I putting words in your mouth?
No, yes, I think that's a fair statement.
Okay. Now, the irony of all ironies is that the people who are concerned about you, some who are concerned about you, women's groups are concerned, not all, pro-choice women's groups who are concerned about you, they are worried you'll use that rationale to overturn Roe v. Wade. That is that, we won't go through it all. Ironically, it seems to me you could read your view as saying, if that hangs in the law another 10 or 15 years, it'd be awful hard. You would, by your own test, have trouble overruling Roe v. Wade. So I guess what I'm asking, without asking about Roe v. Wade, is there a time frame? If it's on the law, on the books, if you will, if it's settled constitutional law for an extended period of time, and the argument to overturn that settled constitutional principle does not, in fact, meet the test of, on its face, being consistent with what the correct constitutional principle is, do you have to stick with what the settled law is? I know that sounds good, but you're making it understandably hard for me because we can't talk about specific cases.
I agree with the statement that long-standing cases are more difficult to overrule than recent cases.
What do you have to find as a matter of constitutional principle to overrule long-standing cases? And I'm not talking about any one case now. Constitutional principles enshrined, it's been there, reaffirmed by cases for 20, 25 years. What do you have to find as a logic to overturn it?
Well, in every case, Senator, you have to find that it's simply wrong, that it's not a correct interpretation of the Constitution.
Okay, that's what we're getting at.
You begin with that.
But how do you...
But as I've said, some cases that are so old, even if you waved in my face a document proving that they were wrong when decided in 1803, I think you'd have to say, sorry, too late.
1969.
Well, that's not 1803.
I really am trying to get a sense of
time is certainly one of them.
What, when is the wine aged?
It's not I don't want to mislead you into thinking it's just a function of time.
No, I don't read it as just a function. As I understand it, if in fact enough time has passed, and notwithstanding the fact you could argue that it was wrongly decided at the time because it was a overgenerous interpretation of a right recognized but expanded, that if it becomes settled practice, and the argument to overturn it is not that it was an incorrect decision 25 years ago, but that, because it was too expansive, but is the argument required to overturn it that clearly, on its face, they disregarded what was the clear intention of the Constitution? Case in point, Plessy versus Ferguson. That was on the book long.
Can I interrupt the senator from Delaware? He asked the question, when is the wine aged?
Well, I understand.
I would say the wine's time has come.
I understand that, but I appreciate his biting humor. But I thought this was a serious line of questioning. I'll cease and let my...
Well, it's not a question of cutting you
all right.
off. It's a question that the senator from Illinois has been waiting and...
Senator from Illinois just asked questions. If he can ask them again, I have no further questions. Thank you very much.